Bismillahirrahmanirrahim. I'm sorry I'm not prepared on the topic of negotiation, nor am an expert like Dr. Joe. But I try my utmost ability to learn the things from the Judicial Academy, but they have not allowed me to attend your session due to my own extreme engagements. But the judge's role in the negotiation concept is very essential and important, but a judge should not cross that red line which call him as a biased judge. So that is a minimum standard to be looked into, and a judge would be fair and manage that negotiation if the outcome of that negotiation comes legally enforceable. So that is the legal perspective, and you in this last 24 hours must learn many things of the negotiation skills, including the Islamic principles in the negotiation. I have seen the schedule of the events, but I will give you another important concept for learning perspective of the negotiation. I've gone through a lawyer's life known as James B. Donovan, an American lawyer who is an insurance lawyer and participated in the trial of a Soviet spy in the 1960s. And the Supreme Court of US convicted that spy with the 5-4 ratio, and he only argued his case on a single line, that death penalty should not be awarded to him, and he should be given a chance for a life imprisonment, so that in future, if there is a negotiation of Americans and the Soviet in the Cold War era, so this man will play a role. And I came to know about this lawyer from a movie, Bridges of Spies, by the Hollywood. Must-see movie. And that movie actually comes from that perspective of how a lawyer can negotiate in those times of the Cold War, where one American pilot whose plane was shot down in that area, and he was captured by the Soviets in the U-2 incident. And he negotiated that convicted spy of the US, of the Russians, with the Russian KGB agents. And that movie will give you the entire perspective of the negotiations. And in this perspective, we are also mindful of the fact that in Pakistan, we have gone through the Tashkent Declaration that is based upon the negotiation skills of the diplomats at that time in 1966. The Indus Water Treaty is one of the biggest negotiations of India and Pakistan, and especially with the World Bank. And similarly, the Afghan-Pakistan Action Plan for Peace in 2018. And the most renowned negotiations were carried out in the Hudaybiyah Accord in the Islamic history. So these all are the events which formulated the history of the negotiations. So I'll recommend you the movie of the Hollywood, The Bridges of the Spy. And you should start learning with a new perspective of the skill which a lawyer can present and what the diplomats and the governments can perform. Thank you very much.
Thank you so much, sir, for sharing your invaluable thoughts. Moving further, we are all honored to have Honorable Justice Syed Mansoor Ali Shah with us today, because his unwavering commitment to promote ADR realm of Pakistan, we can all witness that. So I would really humbly request Honorable Justice Syed Mansoor Ali Shah to please join us here and address this honorable gathering.
Thank you so much. Thank you. Let me first start by thanking Professor Dr. Jo Chitlik. I heard about her in Karachi when I was at the IBA, and I thought that the topic at IBA was ADR Renaissance, and I thought that was a wonderful way of looking at the whole thing, and I thought that IBA has come up with the term, till they very frankly admitted that no, it was Professor Jo Chitlik, it's her term. So wonderful. I think it is ADR Renaissance in Pakistan now. Thank you so much for that wonderful term. And we try to use it now in our literature. Thank you so much. And thank you so much for being here, associating with us, telling us about negotiation. I'll just talk about what our plan is. Thank you to Zarish Fatma also. She's from the Fatma Jinnah University. Thank you so much for partnering with us. Thank you to Fulbright also for putting this event together. So thank you all, and thank you to the participants for taking interest. I know ADR is absolutely essential area for us, and we've said it many times. I don't think we can get rid of or deal with 2.4 million cases in Pakistan the way they are right now. It's a very litigious society that we come from. And with this, the number of judges that we have, which is about only 4,000, I don't think litigation is an answer to this. And we see dependency rising every day. There has to be some sort of a alternative to this entire litigation landscape that we have. And the only option, it's not rocket science, it's happening all over the world. We have ADR facilities in the world. I think the best migration and the best solution to our litigation is ADR. And we have to move on to mediation and arbitration. Without that, I do not see the system is going to get clogged, because this number of cases that we have, they are not going down. If you look at the figures, we're adding cases every year. We're not going down this figure. You would not have seen that 2.43 has gone down. It cannot, because it's not possible to deal with this number unless we come up with a smart solution. To my mind, that is ADR. We need to also culturally change the country by making people understand, by making litigants understand that it is the court that comes at the end of the story, and we need to start negotiating, talking to each other, mediating, and then leading to arbitration if required. But that is where we end our dispute. That is the only space to end our dispute. And only in worst to worst situation, which requires some sort of, as I said yesterday, some interpretation of law, then would you end up going to court. So that's not the choice that you have. So we need to take the courts off the table. Tell people that, listen, you need to settle your matters in the space that you have, and the new space is ADR centers. And you as judges need to understand this. You need to start sending these matters over to ADR. And as I see it, I think if suppose in a particular district we just have one ADR center that might be established soon, it should lead to more centers and the courts should be reduced. More of you sitting in a district should actually be doing ADR, and a very few judges doing actual litigational work. That's how it should move. In future, 60% or 70% of the work is actually being handled at the ADR level, and only 20 to 30% handled at the litigation level. That is the model. That is the successful model that we have to arrive. It might appear to you that it is very, a bit fanciful right now, but it's not. That is the future. 70% of our disputes need to settle at the ADR, and maybe 30%, because of their complexity and because of the interpretational issues, should go to court. So court should not be there in your life. And I'm talking about a litigant. They must have this other space available. You could do that. You could create that trend. I've been also saying that, you see, this movement that Dr. Chitlik has so rightly said, the ADR movement, and we're living through history, we can only carry it through if we understand that this can only happen if the judiciary plays a role. This cannot happen at private centers to start with, because people don't understand this. An ordinary litigant will never trust a private sector center in Pakistan. We get said, if somebody has to mediate our dispute, it has to be a judge. That's a cultural understanding. Please understand that. They would not like to go to a respected citizen of the area or a doctor or an engineer for that matter, they would want a judge to resolve their dispute, even though at a mediation level. So this is something what they've already said this, and we did a survey and that's what we got. So I think we can play a major role in getting this movement started. And once it started, then yes, the private players will come in. I wish them all the best to do that as we speak. But the real change is going to come from the districts, and I tell you why. In Punjab, when we did the ADR, and we did it in 36 districts, in a couple of months, we had thousands of cases moving from the courts onto the ADR, and with a success of about 60%. That is not the case in a private sector domain. You see, we talk about 1, 2, 10, 20 cases. We have 2.43 million cases in Pakistan. So the bulk of the work is in the judiciary. So we need to understand, and if you have that on your table every day, that a case that comes to you, you have number one ADR facility available, and you have that in your mind, you can send that case over to the ADR center, which is going to be, inshallah, established in every district. And that does the trick. We want to do that at the High Court level also. Islamabad High Court is right here. And I must also thank Justice Mohsen Kiyani for always supporting the FGA. He's been there. He's been coming for lectures. He's been giving support. He went for a delegation to Manila recently. And everybody that I talked to at the FGA talks highly about you, for your support and the kind of push that you're giving them. Thank you so much for that. So, and Islamabad High Court is already looking at it. They set up the center. They have set up, they come up the rules. The only High Court that's come up with rules and all that. So I wish them luck and all the best. But I think the area is the districts where we plan to start, and it cannot happen without your participation. You'll have to have that kind of mindset of moving every case, if you can think, onto the ADR. We'll have to sort of look at the point systems and how your performance is marked and all that. I think if you effectively send a matter to ADR and that gets resolved, you should get credit for that also, which is not so currently because the unit structure works differently. But we need to build into our unit structure and your performance evaluation. The concept of ADR needs to come into your working also. So, I just wanted to actually thank Dr. Chitlik, because negotiation is the key. And I wish all the judges of the Constitutional Court also get to negotiate. I think the country right now needs a negotiator for the current crisis we are in. And I wish we had a negotiator. And I don't know if you could stay back and resolve some of our problems at the constitutional level. That would be great fun. But otherwise, I think judges of the Constitutional Court need to sit through this course. I myself really wanted to sit through this course to understand. I was just caught up with other things. We need to, at a different level, understand how to communicate. And if you have that on your table every day, that a case that comes to you, you have number one ADR facility available, and you have that in your mind, you can send that case over to the ADR center, which is going to be, inshallah, established in every district. And that does the trick. We want to do that at the High Court level also. Islamabad High Court is right here. And I must also thank Justice Mohsen Kiyani for always supporting the FGA. He's been there. He's been coming for lectures. He's been giving support. He went for a delegation to Manila recently. And everybody that I talked to at the FGA talks highly about you, for your support and the kind of push that you're giving them. Thank you so much for that. So, and Islamabad High Court is already looking at it. They set up the center. They have set up, they come up the rules. The only High Court that's come up with rules and all that. So I wish them luck and all the best. But I think the area is the districts where we plan to start, and it cannot happen without your participation. You'll have to have that kind of mindset of moving every case, if you can think, onto the ADR. We'll have to sort of look at the point systems and how your performance is marked and all that. I think if you effectively send a matter to ADR and that gets resolved, you should get credit for that also, which is not so currently because the unit structure works differently. But we need to build into our unit structure and your performance evaluation. The concept of ADR needs to come into your working also. So, I just wanted to actually thank Dr. Chitlik, because negotiation is the key. And I wish all the judges of the Constitutional Court also get to negotiate. I think the country right now needs a negotiator for the current crisis we are in. And I wish we had a negotiator. And I don't know if you can stay back and resolve some of our problems at the constitutional level. That would be great fun. But otherwise, I think judges of the Constitutional Court need to sit through this course. I myself really wanted to sit through this course to understand. I was just caught up with other things. We need to, at a different level, understand how to communicate. I think negotiation and communication go hand in hand. I mean, I'm saying it in layman's sense, but I think other than the ADR and dispute resolution world, negotiation and communication helps institutions grow, because that's the way you talk to each other. For example, in the judiciary itself, today if I'm here, I talk to my judges. You see, it makes a lot of difference. I need to communicate with them. We were here last time, we were having dinner and all. We just sat down and talked. Unless my sessions judge or senior civil judge or civil judge talks to a Supreme Court judge, the institution cannot possibly take off. We need to break all the barriers to communicate. And I think negotiation, communication, they're one big family to me. We need to start the ability to talk. And I think that works very well for you within the districts. I hear that, you know, there are session judges that you cannot speak to as a civil judge. You can't speak to your session judge. Well, I'm telling you, I'm a senior punitive judge of the Supreme Court. Talk to me anytime you want. That is the kind of opening of the doors that's required for the institution to grow. You know. So I think we take a lesson at a personal level. One is the dispute settlement. Fine, we've talked about that. But I think we can carry this concept of negotiation, communication, openness into our private lives to make this institution get strong also. So I think I would request session judges who a lot of civil judges can't speak to, not the right model. Cannot work. You need to make things more, you know, comfortable, more communicative, more deliberative, so people come and talk to you. They can tell you their problems. And I tell you, I assure you that the performance is going to change. If you're comfortable, I think love wins it all, you see. Communication wins it all. Creating, you know, walls, having egos, creating an artificial facade of seriousness does not work in any healthy institution. Healthy institutions work with love and care for each other. The more you care for your judge, he'll care for you, you see. So I think all of this is coming out of negotiation to me. It's all coming out of love and affection for others and care for other human beings, because unless you have this sense of caring for the others, you cannot negotiate, you cannot settle disputes. This is all about care, because if you're even resolving disputes, it's about care and concern for the others and other human beings. So I think as an institution, I would like to say that let there be more love in the institution. Let there be more respect and care for each other in the institution. Institutions grow like this. They become stronger like this. So my request to session judges is, you know, relax and open your doors to your judges. Talk to them so that you become a very interesting, communicative kind of a little institution that works together. We've opened doors. As I said, I'm open. You can meet me anytime you want while I'm here visiting, and I'm sure that's how Justice Kani is. And he's taken his time out to just come here, be with us. We want to talk. We want to meet up. So let that be also a takeaway from negotiations course. Not really in the dispute settlement context, but as making yourself in your institution more deliberative and more communicative in that manner. So once again, let me just thank Professor Chitlik. As I said, I really wanted to attend the course myself, and I hope I get some recordings of her, and I want to show it to my colleagues, because we all are in dearth of negotiations back home, and I hope we get to learn how to negotiate and talk to each other and make the institution very strong. I think we're very bright judges. We have very hard-working judges. It's just that if we channelize the energy rightly, I think it could be one of the strongest institutions in the country which could deliver justice. And that's all we need. And that's a life lived, you see, wonderfully lived. Thank you so much for this.